Thanks for coming. I know I'm the last thing standing between you and beer, so I'll try and make this as fun as possible. I'm going to talk about software patent litigation, which has changed a lot over the last 10, 15 years, and we have lots of data. So with lots of data, we have lots of information. One caveat, I'm not a lawyer. I'm definitely not your lawyer. This is not legal advice. Please don't raise your hand and ask me about your friend's company that is being sued, because we're on camera. I don't have to be a lawyer to tell you that your lawyer would tell you not to do that. So don't do that. I assume everyone who is here has at least some inkling that there's been a lot of software patent litigation, right? Okay, fantastic. Part of the reason for that is that we have a lot of patents. So this is from 2014, 300,000 utility patents were issued. Those are not all software patents. Maybe half of them have something to do with hardware, software, or business methods on the web. At first glance, that might seem like, wow, what a great time we live in. You know, 300,000 patents means tons of innovation, right? Not so much. Since the US Patent Office decided to sort of affirm that patents on software would be eligible for people to sue on, they started giving out more and more patents. And the people who write patents got better and better at writing them. And they started writing them in a way that we call functional claiming. So this is a little different than saying I invented a thing. It's saying I've identified a problem and I plan to fix it with software. Obviously, like the actual software patent application is a little bit longer than that, but they said that software was enough of a method for fixing it, and that the U.S. Patent Office would grant you your application based on that, which sounds crazy, but underfunded, overworked government agency, and then dealing with 300,000 plus patent applications a year means that they don't really get to look at each one of them for very long. And in fact, it's usually about 8 hours per application. So if you can imagine looking at 10 to 20 pages written by a lawyer who spent 5 minutes talking with a developer to try and write something that would be confusing to the US Patent Examiner, then they have 8 hours to find prior art for that, each individual thing. Yeah? Oh, a functional claim. So an invention, so if you go back to, like, say, a physical thing, so maybe you're making a better cake pan or something. So you say, okay, so here's this thing. This cake pan always burns the cake. No good. I identify this problem, and then if you were doing a physical invention, you would be like, I figured out a material that makes a better cake pan that doesn't burn the cake, and this is what it's made of, and how it's shaped, and all of these different things. So that would be, you've identified a problem, you've described how you're going to fix it, you have described the utility of the invention. With a software patent, you say, I've identified a problem, and I plan to fix it with software. Like, just with software. And you might say a little bit more, but you don't provide source code, and you don't provide, like, even maybe pseudocode for that. You provide, like, some words about a database, and some words about the network, and some words about, like, oh, we're going to, use this type of an algorithm. And so you haven't actually written the code necessarily in order to get that patent. And even if you have written the code, like, it's not described well enough in the patent for it to be replicated by another person. So on the cake pan application, or that example, if you were to write that patent and you were a cake pan maker, I don't know if anyone in here makes cakes or pans, but the idea would be that if you were a cake pan maker, you would be able to replicate the invention that was being described. That is not the case with a software patent, because it says with software, using some algorithms, maybe like some ideas about like which machines talk to which other machines. But you wouldn't necessarily then be able to, oh, I know what it is. Like, I can go and make that thing again. Does that make sense? Okay. So you can see this utility patent number is kind of horrifying. It keeps going. Lots of patents means lots of patent lawsuits. We also I hear this a lot when I go outside of the US. They're like, oh, you guys are so nuts in the US. Like, you have this problem with software patents. But it's one that we're increasingly exporting for good or ill, along with tasty snack foods and sugary soda. We're also sending out software patents. So about 50% of the patents that are granted in the US are given to inventors outside the US. Just to kind of take a little bit of a snapshot of the global situation, as I said, we're seeing software patents in other jurisdictions too. So even the European Patent Office, where they have a stricter description of what is eligible for patentability, they still have many, many software patents on the books. And Australia is starting to catch up, and China has just kind of in the last few years gone from almost none to 9,000. So we're seeing this in different places. Some places, Germany has very, very strict standards. I just sort of put that in there so you could see it's not necessarily the same in each jurisdiction. But regardless of that, you only need to have one person using the software to have standing to sue in the US. So even if you're making software predominantly in one of these other jurisdictions, you could still be sued for software patent infringement here in the US. So we also know that trolls are active in Europe. They're bringing about 11% of the patent suits there. And so we think that they're lowballing it. After the NPR story here in the US, I think a lot of the non-practicing entities, do people know what I mean by trolls? Oh, yes, okay, great. So a lot of the non-practicing, I think they didn't particularly enjoy the sun being shown under their little rock where they live. And so they've been a little bit quieter in their activities in Europe. But there are definitely offices. I have a friend who, she works on the defensive side, but she was looking for work a year or two ago and got headhunted by what she figured out was probably Intellectual Ventures trying to open a European office. So we also know that around the world, a lot of the Microsoft mobile patents are bringing in money everywhere. They're sending letters all the time. That is a constant source of revenue, those Nokia patents for them. So money is coming in via the patent suit regime all over the world. So, and one other thing that I found that was kind of interesting is that foreign inventors tend to be more successful in the US courts than domestic inventors. We don't know why that is. They may be using more robust patents that are a little bit more specific, or maybe it's the accent, I don't know. It might work on me if I was on the jury, but anyway. So that's kind of the big picture, just to get that out of the way, that we have lots of patents here. We're exporting this idea of patenting software to other jurisdictions, and we're welcoming foreign inventors to come and bring lawsuits here or get sued here, depending on which end of the stick you're on. So, do we have any lawyers in the room? None. Okay. So I'm going to next talk about lawyers and trolls a bit more. Trolls get a lot of coverage because, here in the US, we don't like people that don't work, I guess. It's one of our things, or at least pretend to not do that. So the troll thing, I don't want to, it's not nothing, but it's also not the only thing. And in fact, we have this problem where the line between practicing entities and non-practicing entities has been getting blurrier and blurrier. It's as if, you saw someone running away with candy and then was like, hey, buddy, where did you find all the babies? I need some candy. And so you have practicing entities, companies that are like, we thought we were going to maybe go in that direction, but now we're not. Maybe we could just have, a troll arm. Or, a troll wing, or a troll subsidiary. And so we've got these kinds of blurry lines. And they get blurrier and blurrier all the time. So when we talk about non-practicing entities bringing lawsuits, almost 2/3 of the time we're talking about software. And you might wonder, why is that? Why does the universe hate us so much? Or, maybe you don't wonder that. I wonder that sometimes. But The reason is that software is particularly hard to give notice for. So in a physical invention or physical property, you would put a fence around your yard. Or you would say like, oh, here's my cake pan, here's your cake pan. They clearly are different, or they're clearly the same. You obviously copied me. And so it's very easy for someone to see when something's been copied or someone else's invention has been infringed on. Not so with software. It's abstract. You could be using some sort of database optimization over here for a dating website, and someone else could be using it over here to sell yarn. And it could be the same algorithm. It could be the same process, just applied to a different realm. And so the idea that you would be way over here and had copied someone working in a completely different field of endeavor, you didn't copy them. It's just the best way to have your database talk to your website or whatever it is. So software is particularly fuzzy, abstract, hard to define the limits of. And so that's why trolls love it so much for bringing lawsuits, because if you throw enough money and enough lawyers at a problem, it starts to sound really, really good. Unfortunately, that's the way our legal system works. We also know that contingent fee representation is on the rise. Do people know what I mean by contingent fee representation? It's intended for people who do not have money to be able to access the legal process so that they could get legal representation even if they don't have money. We sometimes call this ambulance chasing in the US. So we're starting to see that, or we've been seeing this for a number of years in the software patent space. What happened was that the economy affected even lawyers. So go back like 10, 15 years, a lot of people entered law school. They thought, oh, this is going to be great. I'll get my subscription to Cigar Aficionado magazine. I'll start picking out a Rolls Royce. Life is going to be good the minute I finish law school. They sold this idea to a lot of people, and it turns out that there were too many lawyers, even by lawyers' standards. And so lots of these lawyers were looking for other ways and other places to find revenue. So they went and they're like, hey, it looks like you've got some patents you're not using. Maybe I could bring some lawsuits on them for, on your behalf, and then we could split the money. So this is happening at large firms, this is happening at mid-sized firms, this is happening at individual boutique firms, all the way up and down the chain. This is an anonymous quote from someone saying that even with a 40% contingent share, so they're getting 40% of the proceeds, we need at least $5 million in damages to break even, and that's per suit. So in this particular one, they're playing the odds. They expect to win 1 out of 10. So they're suing for $50 million in each suit in order to make it worthwhile. The other 9 companies weren't really doing anything that was close enough even for the courts to decide that they were infringing the patent. And you also see at the mid-level, they go after some of the weaker defendants first before they go after some of the bigger fish so that they can maybe establish a venue like East Texas, or make the patent look a little bit more robust because a whole bunch of other companies have already rolled and paid out, or just to get a little bit of money in the war chest, decorate the office up a little bit, that type of thing. And so they'll go after weaker defendants and then move on to bigger defendants. And then smaller firms, like just a couple of people, 1 or 2, maybe 3, will go with quantity over quality. And these are the companies that send out like hundreds and hundreds and hundreds of letters asking for $1,000, $5,000, $2,000, this, that, and the other thing. So there was a sort of famous one in Vermont where MPHJ sent out letters on imaging technology to everyone that had a copier in the entire state of Vermont. And so they said, we want $1,000 for each user of your copier because you're infringing on our patent. One of the letters that they sent went to a nonprofit organization that helps veterans and people with disabilities get jobs. So they have lots and lots of unemployed people coming in and using the copier. And they were like, that's basically our entire budget. Like, everyone comes in here and uses the copier. So they went to the Attorney General in Vermont for help. And he said, oh, hell no. So they're now being countersued. That doesn't always happen, but it's nice when it does. So, and there are lots and lots of firms that they were like, well, you know, $1,000 is cheaper than calling our lawyer, so okay. So it's been a fairly lucrative strategy, even though it's been small bits. And of course, when you're looking for $50 million, you only need one win out of 10 to make it worthwhile. So a lot of money is changing hands, and I think that's a lot of what is tempting people from the practicing entity only to the, you know, kind of to the dark side. So, you know, it's hard to argue with money, I guess. And even if you do decide to fight back, getting sued still sucks. Even if you have the money and you're like, well, the amount we would pay out in the long run is more than what we would like to do because we want to continue to pursue this avenue of business, it's a huge amount of time and energy and focus. You hire more lawyers. You spend a lot of time thinking about it. You spend time meeting with your lawyers. You end up putting things on hold if part of the lawsuit is that you don't continue shipping that product until it's resolved. That's a huge lost opportunity. So even if you do fight and you have the money to do it, getting sued still sucks. So that's kind of like what has been going on with the way that the lawyers who bring these suits and the trolls that they've been representing have kind of changed and evolved over time to maximize the way that they take advantage of the legal system. Judges and juries have been a little bit different. In the 1990s, defendants of software patent suits or patent suits in general needed to find prior art or prove that the work was out of scope. So to put that in layperson's terms, it means that if you got sued for patent infringement, you had two avenues by which you would likely be able to overcome that suit. You could either say like, oh, I found something from before that patent was issued. It should never have been issued. It's probably a mistake. I had this, you know, this old mailing list from 1986. You issued that patent in 1987. Okay. Or you could say, the thing that they think we're doing is not what we're doing. We're actually doing something else. The courts were extremely reluctant all through the 90s and the early aughts to say, I don't know what they're smoking at the USPTO. That's changed, which is great. So I usually, like, for a while when I would talk about this issue, it would be like zero good news, and so now we have like a little spot of good news, which is where we are now. This case, 2014, the Nautilus versus Biosig ruling. This is when you go to the gym and you put your hands on the hand-shaped things and it takes your blood pressure, right? Nautilus knew that you couldn't get a patent on like human hands because they're natural phenomena. So they went and there were a lot of like really vague verbiage to get patents on hand-shaped things without ever saying hand-shaped. And so when they brought this suit, the Supreme Court eventually went all the way up to the Supreme Court, and they're like, you can't write a patent that is so vague that we don't know what it is. That's just not enforceable, which is new because this is part of that saying the US Patent Office should not have issued this. And so this is a huge change for the courts to be able to say this. They also did it in a slightly different way with the Alice versus CLS Bank ruling. This one was you have party A and party B, and then you ask party C to intermediate a financial transaction between you to make sure everything's on the up and up, which has probably been happening since like cave people times. Like, hey, here's a big bison haunch. Could, you know, when Uggo shows up with all the herbs, can you give him his cut? Something like that. So this is like by no means a novel idea of having a third party intermediate for two other parties. But because it was on a computer, the US Patent Office issued this patent. And the Supreme Court finally said, no, you cannot have a patent on something that is a generic idea implemented on a generic computer. So no more patents that are so vague that we don't know what you're talking about, and no more patents that are blah, 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 regular stuff, comma, on a computer. And then immediately, like within 4 weeks, the Federal Circuit, this is basically like a giant flowery thank you note in legalese, saying like, thank you so much for allowing us to toss this garbage out of our court. This one is, the Digitech one is using two data files to create a device profile on an imaging machine, which is, yeah, it's very, very abstract. And so they were very happy to be able to toss this case out. This one was another one in the lower court where they said, oh, we were really excited also to be able to get rid of this vague one. When you do animation, you assign a number to how open the character's mouth is. And they said, oh, we're going to automate that. People have been doing that forever, and ever since like animals have been talking in cartoons. But they added the word automate to it and wanted a patent on anyone who automates that process. And the court said, that's so broad that no one could make any animation whatsoever without infringing on your patent. So no, you can't have it. So this is huge. This is really great. This is a lot of pushback from the courts saying that the US Patent Office really needs to change the way that they're issuing patents. And they do have new guidelines for the way that they're issuing patents now. Another thing that we noticed is that more experience with patent suits makes judges less likely to rule for the patent holders, even just a second suit. So the first suit, they're like, oh man, I met the person who invented the internet this week at work. It was amazing. We gave him a ton of money because some people were infringing his patent. And then, the next week it was like, this week I met someone else who invented the internet. And they're like, oh no, no, I've seen this one before, So that's great. Judges are like, no. We're getting more savvy. And so you get to see like what's been happening since that Alice case in particular. So the judges are getting a little bit more suspicious. They have some precedences from the Supreme Court on which to rest their decisions and say, yeah, no. And you see, some of them, they weren't all computers. Some of them were business method and other types of patents. But in ones that referenced the Alice decision, only 17% of those patents were upheld. The rest, it was like, nope, that is abstract idea, an idea of itself. I don't even know what that is, but it does not sound patentable. But the big one, the big win is the 51% of the cases. And this was, I think it was 272 cases that have been seen since Alice on this subject matter. 51%, that is just a generic thing implemented on a generic computer. So, yay! You guys, so there's still more bad news, though. I'm sorry. So there, like 4 out of 5 software patents could be bogus if you take those numbers in aggregate and then kind of like spread those out. Maybe there's a couple of reasons why that might not be the case. One, patents are valid until they're challenged. So if you don't have money to fight in court, it doesn't matter if that patent is like a wet piece of toilet paper. It just doesn't matter. If you don't have money to go to court, it's a valid patent, you pay. The other thing is that it's not all of the patents that were brought before the Alice decision are going to be the same as the ones that will be brought after. So I fully expect trolls, practicing entities, non-practicing entities, other people bringing lawsuits because they couldn't sell their product to find other types of patents that skirt around some of the ways that Alice said no and the ways that Nautilus said no. So I think we'll start to see lawsuits on patents that are more specific, which means they won't be like, oh, we could send this letter to 5,000 people. It'll be like, well, we can only send this letter to 50 people, and then we'll send this letter to 50 other, So it makes it more difficult, but we haven't seen the end of software patent suits, is what I'm saying. Plus, that's even if 4 out of 5 of them are invalid, like that's maybe like 200,000-ish, there's still another like 40, 50,000-ish software patents in the US left.
Maybe you're going to answer this later, let me know if you are. Is one of the possible solutions, why aren't they requiring code or implementation in the patents?
So I am not going to talk about that because code is under copyright, because it's written. And so we consider actual software code, source code, to be covered by copyright. Patents cover the function. And so they're probably not going to ever ask for source code because it's the wrong legal tool. It's confusing, and there's a lot of places where it overlaps, and software really kind of lost the straw draw on that one, where we got copyright and patents. But I'm going to mostly talk about patents. If you want to talk about copyright after, let me know. Yeah. So we talked about judges and how they've gotten a little bit more savvy, and they've got a lot more tools in which to get rid of software patent suits that are vague and broad and just generic commuter implementation. Juries are another story. So one of the reasons that Eastern District of Texas is so popular is because there is no tech industry there. It's farmland. And it's mostly older people who, are just they're not tech users by any stretch. And so juries also don't get to come in week after week and see what's going on and try to stay up to date with the particular area that they've been tasked with, because it's just luck of the draw who you get. So we know, like, up to about a year ago, the number was that judges would tend to rule for the patentee only about half of the time. And that number may get better. But juries tend to rule for the patentee over 2/3 of the time. So that's interesting. It means, like, if you were bringing a software patent suit, it would be in your interest to try and get a jury trial, right? Today, over 70% of patent cases are heard by juries. If you go back maybe like 15, 20 years, that number used to be closer to 5%. There was an idea that juries were not qualified to hear patent suits, and somehow that just got obliterated. And now, like I said, 2/3 of the time, you have juries looking at patents and going, yeah, that seems great. Give them some money. So that's kind of like what's going on with the landscape. I'm going to talk a little bit now about what is working and what is not. In some countries, they've been able to put strict limits on the scope of patentability to get rid of, like, a lot of the more egregious software patents where you're just like, that's just, tic-tac-toe, but on a computer. And in some states, we've made some progress where it's actually, in the states that are not blue, it is still legal to bring a patent suit where you don't disclose the real party in interest, you don't say what patent you're suing on, and you don't say what activity you think the defendant is engaging in that infringes on your patent. So, so this is, transparency is good, but unfortunately, we can't impact the scope of patentability at the state level. It's a little bit easier to get things done at the state level, smaller area, smaller, type of thing. So if you're not in one of these states that is blue and you see this issue come up, please make a phone call. So sometimes democracy works, which is cool, and sometimes it doesn't, or it doesn't have an opportunity. I assume most people are a little bit familiar with the Trans-Pacific Partnership Agreement, right? Okay. I'm not going to talk about it a lot. It's like the language just got put up a couple days ago, and it's pretty dense. But this is the piece about about patents. And I think that the trick here is that it is doing what we call harmonizing, which is usually, you should always be suspicious of harmonizing. Harmonizing usually means, like, going towards the lowest common denominator. And so this is kind of like a little bit behind the current state of the scope of patentability in the US. And this would apply to all of the other signatories of the Trans-Pacific Partnership Agreement. And additionally, it would preclude us here in the US from passing reform that limits the scope of patentability beyond what is here. So we're stuck with what we have, and we've exported it to the entire Pacific Rim. That's the short read on that. I'm sure there will be more written on this soon. But this is the actual language that I think is the most germane within the release text of the Trans-Pacific Partnership Agreement. So I told you there was only going to be a little good news, right? Yeah, okay. Another thing that is working, as I said, I work at the Open Invention Network. We run a defensive patent pool where companies that use open source technologies agree to not sue each other. So instead of waiting for federal legislation or state legislation or worldwide domination by someone, nice that would like to see software thrive, we just decided to self-organize and decide to not sue each other. It was basically like 6 larger companies were like, oh, we should skip suing each other this year. And then they asked other companies to join. So there's now 1,800 companies in there. And we also coordinate defensive publishing. So if you wanted to, say, add to what the list of things that you're not able to be sued on, but not write another patent. Sorry, that was sort of a convoluted sentence. You can either give the US Patent Office a patent, or you can tell them, I made this thing, but I want you to make it public, and it will be public prior art. And so don't give anyone else a patent on it. So it's sort of a block against anyone else receiving a patent on that thing. And it's called defensive publishing because you're not trying to get a patent that you can then go sue people with, but you're saying, like, I made this, please don't give someone else a patent on it. And I can, if someone's like, oh, I might want to do that, I'll give you my email at the end. So your homework, and we're getting close to the end here. If you are the kind of person that has kept lots of your mail logs and has been following technology for a really long time, and you want to help bust patents that are patent applications that are being proposed, there are a couple of websites where you can do this. Specific to Linux is linuxdefenders.org, and they're partnered with us at OIN. Trolling Effects is run by the EFF, and they coordinate also finding prior art and blocking bad patents. One of the ones that I saw come through, and this was just like 2 years ago, when you send an email and you're like, blah, blah, blah is attached, and then you click send, but you forgot to actually attach the thing, and then you get the little box that comes like, oh, did you forget? Microsoft was seeking a patent on that just like 2 years ago. So some of the stuff that is up here that you could block is pretty easy, especially if you've been paying attention to stuff for a while. You just need something that somebody has written, or a screen grab that has a good date stamp on it, or something like that. So, if you want to help us patents, that would be awesome. And then the patents at Stack Exchange, they also talk about prior art, but also, are you at Stack Exchange? Yeah. And then I think there's also some conversation about who's getting sued and maybe like people coordinating their responses to letters. So yeah, if you have interest and time, that would be fantastic. Of course, you could join OIN. I'd be happy to talk with you more about that. It's free. And I would urge you to talk to your colleagues. I feel that the narrative around software patent suits is that it's 2 big monster companies like Google, Samsung, Apple, and like your like regular friend is like, I don't know, man, I'm just working as like a public school teacher. Like, I don't care if like Google and Samsung want to beat each other up for a couple $1 trillion. Like, so that narrative, and it's, so those are the kinds of cases that get covered in the news and that type of thing. But it does affect us. Well, for one, it makes everyone's cell phone really expensive when we have most of the money getting poured into lawsuits. But it also means that small and mid-sized companies have to make choices between hiring more lawyers or hiring more developers and IT people. Personally, and I know some great lawyers, but I would rather those companies were able to hire more developers and IT people instead of more lawyers. So, go and talk to your neighbors and your colleagues about that so that they know that this is, this is not just to like save Apple from having to pay out lots of money. And then if you were in one of the states that's not blue, maybe you could pass a law to increase transparency around who brings lawsuits on software patent infringement. And if you're interested in the TPP part, this is a little, I'm just not, we don't work on that at OIN, but I know that the Electronic Frontier Foundation and the Free Software Foundation are both downstairs in the expo hall, and they're both working hard on stopping the TPP. So I would urge you, if that part sounded interesting to you, go talk to them about it. I'm sure they would be happy to get you hooked up. So if you ever have one of those days where you're feeling really cheery and rosy about the world, you can read some of these things that talk about, that's a short URL of the TPP agreement from the New Zealand website. It's also available via EFF. If you want to read about the contingent fee representation, the guy who was quoted anonymously made some pretty obnoxious quotes, so if you get really angry about that. And then there's, I think the other ones are pretty clear. And then, of course, I have picture and font credits, and you would be welcome to email me about any of those things. So thanks so much, and I think I have time for a couple of questions if you want to ask them before we go to beer. Thanks.
Thank you, Deb. Let's thank the speaker. I have a microphone for questions. Does anyone want to start us off? All right.
Yeah, it looks like we're...
Have you seen any effects from companies like Newegg that have a policy of never ever settling with trolls? Are you seeing any effects, like good things happening from that, or is it just that the trolls avoid suing Newegg?
I would say it's probably mostly that the trolls avoid suing Newegg. And Rackspace, who also has that type of policy. They actually, like, if you ever see them, they had this great, like, troll bashing T-shirt that was pretty hilarious. But yeah, I think we're going to see them. I think we're going to see trolls picking their battles a little bit more carefully with the Alice stuff for a while too. So, other questions? Was there another one in the back?
No, doesn't look like it.
All right.
Thank you.
Okay, thanks so much, you guys, and feel free to email me if you have something offline.